It was a scanty courtroom as the Supreme Court put to rest the suit filed by President Muhammadu Buhari and the Attorney General of the Federation, Mr. Abubakar Malami, asking for an order compelling the National Assembly to delete Section 84, subsection 12 of the Electoral Act on the grounds that the section is unconstitutional, illegal, and discriminatory. There have been several debates regarding Section 84, subsection 12 of the amended Electoral Act 2022, which was assented to on the 25th of February 2022 by the President. Upon assenting to the Act, President Buhari had asked the National Assembly to delete the contentious clause. However, Parliament declined the President's request. Meanwhile, one Mr. Nduka Edede approached the Federal High Court in Umuahia, Abia State, seeking the deletion of Section 84, subsection 12 of the Electoral Act on the 18th of March 2022. Thereafter, the court ordered the AGF to delete the amended section of the Act. Dissatisfied with the court verdict, federal lawmakers challenged the decision at the Court of Appeal. And on the 11th of May 2022, a three-man panel of justices led by Justice Hamma Barka held that the Federal High Court Umuahia had no jurisdiction to have entertained the case, since the plaintiff, Mr. Nduka Edede, lacked the locus standi to have filed the suit in the first instance. However, the appellate court wants the Supreme Court to provide interpretation in the suit. Nevertheless, President Muhammadu Buhari and Mr. Malami approached the Apex Court seeking the deletion of Section 84, subsection 12. In taking a decision on the matter, the seven-man panel of the Apex Court unanimously stated that the President lacked the jurisdiction to bring the suit before it because of the nature of the relief sought. The Apex Court's justices also held that having earlier assented to the section, the President cannot turn around to approach the court to strike it out, explaining that the President's request amounts to constitutional violation. The justices add that the suit cannot be entertained by the Apex Court under Section 1, subsection 1A of the Additional Jurisdiction of the Supreme Court Act.
I cannot but to salute the courage, the industry of my noble lord for doing justice to this matter. Cases do come. We have filed our reaction, and my noble lords agree with our reactions to the point that this is not the kind of the matter that should be brought to the Supreme Court, particularly where the President happened to be the part of the maker of that law. You can't appropriate at the same time to be appropriating. You cannot be seen to have done something and at the same time turn around to ask that what you have done should be set aside in this kind of procedure.
The Supreme Court have delivered their judgments, and being the Apex Court, everybody is bound by it. Unfortunately, the merit of the case was not determined. The objections of the defendant was upheld, where the first and second defendant were held not to have sufficient locus to bring the action and to invoke the original jurisdiction of the Supreme Court on the matter. And well, having made that point, they felt there was no need for them to determine the merit of the case, which is on the constitutionality of Section 84.12 of the Constitution, of the Electoral Act.
Section 84, subsection 12 of the Electoral Act holds that no political appointee at any level shall be a voting delegate or be voted for at a convention or congress of any political party for the purpose of nomination of candidates for any election.